Section 15. Breach of contract. Contract law in today's market understanding. Breach of contract in real estate transactions. In the previous chapter, we examined the various legal methods of contract discharge, including cancellation, rescission, assignment, and novation. These legal mechanisms provide structured ways for contracts to end without conflict when the parties follow the proper procedures. However, not all contracts conclude smoothly. When one party fails to fulfill the obligations required under the agreement, the law recognizes this failure as a breach of contract. A breach of contract occurs when a party fails to perform their duties as promised in the agreement without legal justification. Because real estate transactions involve large financial commitments and detailed contractual obligations, breaches can create serious legal and financial consequences for the parties involved. Real estate professionals must understand how breaches occur and how they are handled under contract law. Recognizing the difference between minor contract disputes and serious contractual violations helps licensees guide clients through difficult situations while minimizing risk and liability. What constitutes a breach? A breach of contract occurs when one party fails to perform the obligations required by the agreement. These obligations are typically described in the written contract and may include financial commitments, deadlines, property conditions, or other contractual duties. A breach may occur in several ways. A party may completely fail to perform their contractual duty, perform the obligation incorrectly, or fail to meet the timing requirements specified in the agreement. In real estate transactions, breaches frequently involve issues such as failure to close on the scheduled date, failure to provide required disclosures, or failure to deliver the purchase funds. Courts determine whether a breach has occurred by examining the terms of the contract and the actions of the parties involved. If the contract clearly required a specific action and that action was not completed without a valid legal excuse, the court may determine that a breach has occurred. Material versus minor breach. Not all breaches carry the same legal consequences. Contract law distinguishes between material breaches and minor breaches, depending on how significantly the failure affects the overall agreement. A material breach occurs when one party fails to perform a critical obligation that is essential to the purpose of the contract. When a material breach occurs, the non-breaching party is typically released from their contractual obligations and may pursue legal remedies. For example, if a buyer fails to provide the purchase funds at closing, the seller may consider this a material breach because the buyer has failed to complete the primary obligation of the agreement. A minor breach, sometimes referred to as a partial breach, occurs when a party fails to fulfill a small or non-essential part of the contract, but still substantially performs the overall agreement. In these situations, the non-breaching party may still be entitled to compensation for damages, but may not be allowed to cancel the contract entirely. For example, if a seller agrees to repair several minor cosmetic issues before closing, but fails to complete one of the minor repairs, the buyer may still be required to proceed with the transaction while seeking compensation for the incomplete repair. Anticipatory breach. An anticipatory breach, also known as anticipatory repudiation, occurs when one party clearly indicates that they will not fulfill their contractual obligations before the performance deadline arrives. This type of breach allows the non-breaching party to take action before the scheduled performance date, because the other party has already demonstrated an intention not to perform. Courts generally require a clear and definite indication that the party will not complete the contract. For example, imagine a buyer who informs the seller several weeks before closing that they will not be able to obtain financing and do not intend to proceed with the purchase. Even though the closing date has not yet arrived, the buyer's statement may constitute an anticipatory breach because the buyer has clearly communicated their inability to perform the contract. Recognizing anticipatory breach allows the non-breaching party to pursue remedies without waiting for the actual performance deadline to pass. Breach in real estate transactions. Breach of contract occurs in real estate transactions for a variety of reasons. Some breaches are the result of financial limitations, while others occur due to misunderstandings or disputes over contract terms. Common examples of breach in real estate transactions include: the buyer fails to secure financing and cannot complete the purchase. The seller refuses to transfer ownership of the property after accepting the contract. One party fails to meet a contractual deadline for performance. Required disclosures are intentionally withheld. Earnest money is not deposited according to the terms of the agreement. When a breach occurs, the injured party may seek remedies such as damages, rescission, or specific performance depending on the circumstances of the transaction. These remedies are designed to restore fairness and compensate the non-breaching party for losses resulting from the breach. Real estate professionals should approach breach situations carefully by documenting communications, reviewing the contract terms, and encouraging parties to seek legal guidance when disputes arise. Online discussion. 1. Question: why does contract law distinguish between material breaches and minor breaches? Answer: the distinction helps determine the appropriate legal response. A material breach significantly affects the purpose of the contract and may allow the non-breaching party to cancel the agreement, while a minor breach may only result in compensation for damages. 2. Question: what is the advantage of recognizing an anticipatory breach before the contract performance date arrives? Answer: recognizing anticipatory breach allows the non-breaching party to take legal action immediately rather than waiting until the performance deadline passes. This can help minimize financial losses and provide clarity regarding the status of the agreement. 3. Question: why is documentation important when a breach of contract occurs in a real estate transaction? Answer: proper documentation provides evidence of what actions occurred during the transaction and helps determine whether a breach actually took place. Written records may also be used in court if the dispute leads to legal proceedings.